As a senior analyst within Ascend by Cirium, I've worked within the consultancy team for over 25 years, covering all aircraft types. I'm also a certified ISTAT appraiser and a certified civil expert witness. I'm going to provide you with a very brief insight into the interesting work of the expert witness. We'll look at the definitions of an expert, the roles they play, the types of clients they serve, and the work they undertake. So what is an expert witness? Well, he or she is a specialist in a particular field who is asked to give an independent opinion on the facts of a case. That word independent is very, very important. Their role in court is to help the decision maker, who could be a judge, a jury, or a magistrate, to understand the case and to interpret the facts. In an arbitration, he or she will take part in a dialogue with the other party through a mediator to try to reach a settlement. To call yourself an expert in any subject, you must have a wide breadth of experience in a particular field with associated qualifications. The expert must always provide an independent opinion, as we spoke of before, irrespective of which party he is representing. He or she must never be coerced by a client to give an opinion that he does not agree with, or be asked to alter a report which alters its context in any way. In fact, most disputes are resolved before ending up in either court or arbitration, as both of these processes can be very costly and time-consuming. Arbitration and courts are the two main types of proceedings an expert witness may find themselves in. So let's look at them in more detail. First, arbitration. This is a form of mediation between two parties with an independent arbitrator. The arbitrator usually has extensive experience within the field of dispute, and their role is to manage a respectful conversation between both sides to try to reach a mutually agreeable settlement. The mediation process is a less formal process than court proceedings and can take place at convenient locations such as offices, hotels, and conference centres. Court is a formal High Court County Court proceeding. This can be very time-consuming and expensive, with the judge or magistrate relying on the expert to give them sufficient knowledge to help the jury or judge reach a verdict. The waiting list for cases to be heard can actually extend to years. We at Ascend by Cirium have acted for a wide spectrum of clients who have come from the sectors of insurance, law, auditing, aircraft leasing, manufacturing, as well as aircraft owners themselves. All have one aim, and that is to obtain an independent expert report that explains the facts behind a particular dispute in a clear, concise, and intelligible manner. So why would these clients need an expert report? Many cases that we've been involved in relate to aircraft that have been damaged as a result of accidents, the cause of which can vary. No two cases we deal with are the same, but aircraft damaged on the production line or whilst having a maintenance visit continue to be quite common cases. For example, we assisted a client in assessing a potential loss in value, a diminution in value, to a Prestige corporate jet, which was at the final assembly stage when the jacking system failed. That resulted in the machinery penetrating the aircraft fuselage. Another type of frequent case is damage to aircraft caused by airport vehicles. A diminution in value report due to damage history can involve all aircraft asset classes, namely commercial, business jets, helicopters, and general aviation aircraft. It is important to stress here that the loss in value due to damage history should not be confused with the cost of repairs, which is usually covered by an insurance policy and paid out fairly quickly after an incident. Any loss in value claim can sometimes take many years to resolve. Potential buyers of aircraft can demand a discount to the purchase price because of his damage history, and an expert report could be required to ascertain if such a situation exists. An expert report, in this context, will look in depth at many factors, such as the market, the type and extent of damage sustained, the quality of the repair proposals, and whether any additional special inspections have been imposed as a result of this damage. The resulting loss in value opinion is given as a percentage, which can then be applied to the retrospective market value at the date immediately before the incident took place. Now, many people believe that if an aircraft is repaired back to a condition that is actually better than it was before the accident, then there should be no loss in value. This sounds logical, doesn't it? But in fact, the perception issue is a very strong one indeed, especially for corporate jets, where the millionaire high net worth individual tends to shy away from damaged goods because he has the wealth to choose not to. The aircraft, although perfectly repaired, still has the stigma of damaged history. Other types of cases can involve the potential loss in value through incomplete records or aircraft that are in a serious state of disrepair and neglect. You may be surprised to learn that missing or lost records can in fact make an aircraft worthless. In any type of case, the court-compliant expert report must thoroughly explain the background to the case, explain coherently the reasons for the concluding opinion, and state all the sourced documentation used to reach this opinion. A diminution in value report, which concludes no loss in value, is also very important to a seller who wishes to prove to a potential buyer that the damage sustained does not have any effect on value. To conclude, I hope this brief background to the expert witness role has been interesting. Thank you for watching, and do get in touch if you would like further information.